Welcome everyone today to this webinar. I'm going to be recording it, and the webinar is about asylum and FGM. We're going to focus on asylum law and policy and FGM protection orders. Dr. Peter William Walsh is going to start the webinar, and he is a researcher at the Migration Observatory at the University of Oxford. His research focuses on UK immigration policy. His doctoral thesis was at the University of Cambridge in the sociology department, where he focused on legislature in immigration policy making, a liberal constraint. I'm Dr. Charlotte Proudman. I'm a barrister at Goldsmith Chambers, and I specialise in violence against women and girls, and I've appeared in a number of FGM protection order cases. I'm also a junior research fellow at Queen's College, Cambridge, where again I specialise in FGM law and policy, having completed my doctorate at King's College, Cambridge. I'm going to hand over to Peter now, who's going to take you through the first part of the webinar. He's going to speak for about 20 minutes, focusing on asylum law, and then I'm going to speak to you for about 20 minutes on FGM, asylum, and also FGM protection orders. And we'll have about 20 minutes thereafter for questions and hope to conclude at 3 p.m. so you can enjoy the rest of your day. Thank you. Peter.
Charlotte, thank you very much indeed. A huge thank you to everyone here today. It's a pleasure to be back in Cambridge, even if only virtually, to give some background about the Migration Observatory where I work. This is an independent and non-political research institute that analyses and reports on evidence about immigration to the UK. The evidence that I'm going to present today is from a briefing that I wrote for the Observatory last year. Our briefings are our stock in trade. They're research reports of about 3,000 words that examine a specific aspect of UK immigration. We have about 20 of them, and we update them every year. We have them on family migration, student migration, citizenship, detention, deportation, and today I'll be presenting to you on asylum. I'll be trying to provide a broad, largely quantitative overview of asylum in the UK, upon which Charlotte will build by presenting from a legal perspective asylum seeking due to FGM in particular. But what I think made this particular briefing on asylum especially interesting is the media attention that it received. So here I am speaking on the BBC, summarising some of the main findings of my research. This was on BBC 2. I can confirm that I was a very long way away from the buildings in the background there. I was in front of an animated green screen. But it is unusual for a technical research report of this kind to attract this much media attention and reach a broad audience. And so I wanted to share with you a little bit of the process of how I framed this research to maximize its appeal, especially to the media, so it could reach a broader audience. So my research began with a little known question in the annual population survey. So this is the UK's nationally representative survey of households, and it's used to provide estimates of the UK population. Now, foreign-born respondents are asked in this survey when they originally came to the UK and why. So my mum, for example, would have said, she came to the UK when she was 21 years old for the purposes of work, to take up a job as a nurse in the NHS. And when the responses to this question are analysed, we find that there's an estimated 360,000 people who say they originally came to the UK to seek asylum. And we know when, and so this allows us to build up a picture of how long people who came to the UK to seek asylum have lived in the country for. And what we see is that between 60 and 20 years ago, over 110,000 people sought asylum in the UK. And this is about a third of all of the people living in the UK. And so from this, we can compare this information with broader analyses over time of the number of asylum seekers in the UK. And we see that indeed in this period, 16 to 20 years ago, before 2018, we do have this rather big spike in asylum applications, an average of 100,000 people seeking asylum in the UK per year at that time. And when we look at what was happening geopolitically, we can see that that spike coincided with conflicts in Afghanistan, in Iraq, Somalia, and the former Yugoslavia. Explaining the first spike here in the early 1990s, well, that's due to conflicts in Sri Lanka and in large part the Somalian civil war. Now, in recent years, we no longer have 100,000 people seeking asylum in the UK. We have between 30 and 40,000, 2/3 of whom are male. But these are asylum seekers, and not every person seeking asylum is granted protection. So how many people are actually granted a form of protection that seek asylum? The blue bars here show those who were granted protection each year. And I think in about the last decade or so, between 1/4 and 1/3 of people have been granted asylum. But crucially, this is at what's known as initial decision. So these are the first decisions that are made by the Home Office, and they don't take into account the appeals process. And when we do, we can see that there are actually 4 stages to applying for asylum. We have the first stage where we have the applications, we have the Home Office's initial decision. In recent years, 38% of people who applied were granted a form of leave, 62% were rejected. But then we have appeals. And we find that in recent years, 4/5 of rejected applicants have appealed. And of those appeals that have gone through, a few are withdrawn and a few are still awaiting the outcome on, 40% were successful. So this really gives us some insight into the quality of initial decision-making by Home Office caseworkers. We can see the effect that this has in recent years, an increase of 38 to 55%. And looking over time, we can see that the grant rate after appeal does substantially increase the number of people who are granted asylum in the UK. And that's got bigger over time because immigration judges have increasingly ruled that the initial decisions made by Home Office personnel were in error. So that gives us some insight into the quality of initial decision making, but asylum decision makers don't only frequently make the wrong decisions, they also take a long time to do so, effectively putting the asylum seekers' lives on hold. They'll be given accommodation in the UK, but this is how long they have to wait. The share of applications that were concluded in 12 months, that's fallen from 60% in 2011-12, this is a financial year, to 35% at the most recent count. But what's especially striking here is the orange line. So this is the share concluded in 36 months, and that's 64%. So that suggests that of a cohort of applications that turned 3 years old in the most recent financial year, only 64% have been concluded, 36% having to wait for longer than 3 years. But perhaps a more interesting and useful metric of the time it takes for asylum applications to be processed is those that receive an initial decision from the Home Office within 6 months. Because the appeals take a long time, and it's through no fault of the Home Office's own. The legal system of asylum is complex, it's tortuous. So this perhaps gives us a better measure of how the Home Office is doing in its duty to process these applications as quickly as it can. Now, they have had a goal for several years to process asylum applications within 6 months. We see in 2012, 73% of applications were, rose to 80% at the start of 2014. We don't have any explanation for the dip there, but what's really striking is what happened after 2014, quarter on quarter declines in the share of applications receiving an initial decision within 6 months. Now, when I calculated this, I thought that there might have been some mistake. I knew that the data for this, the Home Office transparency data is what they call this data release. It's a bit of a running gag amongst statisticians because it's not very transparent at all. It's very difficult to make sense of. So I wrote to the Home Office to ask them to check my sums, and their response was quite instructive, more for what they didn't say, for what they did. So this was their response. I was seeking confirmation that I got the sums right. And they said that they are committed to ensuring that asylum claims are considered with unnecessary delay, to ensure that individuals who need protection are granted asylum as soon as blah, 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 blah. Okay, and it went on like this. But the key section was this. Whilst we take steps to increase capacity and focus on process improvements to deliver better qualities of decisions more efficiently, we have moved away from the 6-month service standard. And that was quite quietly done, not without any fanfare. But what this essentially told me was that, yeah, the sums were correct, and that's no longer a goal that they're going to pursue. But none of this, of course, explains why decision-making is so often erroneous and why it takes so long. And I wanted to explain some of the accepted reasons for why this is. And I have 4 reasons, and I think it's important to recognise that first, asylum cases are extraordinarily complicated. Charlotte will flesh this out a little bit later. The decision letters are typically between 5,000 and 17,000 words long. Now, it is true that there's a lot of copy and paste there. There was one man who found out this recently to his peril. He was told that unfortunately he was going to be returned to his native Iran, quite apart from the fact that he was a Jamaican man and was trying to seek asylum having left Jamaica. But they are long and they are complicated. There are 50 documents of guidance given to asylum caseworkers who are not well paid and are overworked and overstressed. So given that we have so many applications and that they are complicated, it perhaps is no surprise that there is a culture of speed. It's in the Home Office, and whistleblowers have said that they are under pressure to make 5 decisions per week. So that's drafting as many as 50,000 words of decision letters. And that's based on an interview that, according to the recommended guidelines, shouldn't go on for longer than 2 hours. And there is a quote from a caseworker, a whistleblower, that I think conveys the kind of structural constraints within which they work quite well. It does require online research to check some of the facts in asylum claims, but actually doing that, doing one's job, would eat into the time stats, and that caseworker would get a black mark against their performance. So that's the second reason, the culture of speed. The third reason is that the Home Office is understaffed. They do process tens of thousands, 40,000 in recent years, applications per year. There are thousands of staff in UK visas and immigration, up to 100, 200 caseworkers working on applications at any one time, but that is not enough. And in recent years, there have been cuts to Home Office funding, which has made their job even more difficult. The final point that explains some of these patterns is poor staff retention. So it was recently discovered that more than a quarter of Home Office staff who take decisions on asylum cases quit over a 6-month period. And this doesn't give the opportunity for the kind of passing down of institutional memory that allows the rules of thumb that make for good decisions to take place. So those are some of the important things that we have to recognise to explain these patterns that we see in decision making. Now, while asylum seekers await a decision on their claim, it is the policy to disperse them around the country. And the aim is that this dispersal ought to be fairly uniform to prevent no local authority having to shoulder a greater asylum burden than others. So I looked into this, and I have here a bar chart showing the distribution of asylum seekers across the UK by region on the left, and as a share of the population. And so this shows that relative to population, the northeast, the northwest is taking more than their fair share of asylum seekers, while the southeast and London less so. I can show this data in a different way using a map. The circles here indicate the number of asylum seekers that are housed in these local authorities, with the size of the circles corresponding to the number. So we can see in Scotland now, the big circle is Glasgow that hosts 4,000 asylum seekers. And again, this shows a clear pattern with higher concentrations of asylum seekers in the Midlands, in the Northwest, and in the Northeast. And actually, when you crunch the numbers, you find that there are as many asylum seekers hosted in just 20 local authorities as there are in the remaining 362. So it's highly uneven. And I think I have an explanation for this pattern. A different pattern used to persist, and it used to be that asylum seekers were hosted by and large in the southeast and in London, and that's because the rules stated that where someone applied for asylum, and people often landed at Dover, having crossed the Channel, they had to be housed in the local authority in which they applied. And so this is why the dispersal policy was introduced, but it clearly hasn't made good on its goals. And ironically enough, the distribution is almost as uneven as it was 20 years ago when it was introduced. Part of the pattern that we can use to explain it is the way it's funded. So private contractors are given multi-billion-dollar contracts, and it's their responsibility to house asylum seekers. And of course, there is a strong pressure on them to house asylum seekers in areas where accommodation is cheaper. So that explains, in large part, the patterns that we see. With regard to some of the personal characteristics of asylum seekers, we don't know that much, but we do know their nationality. We see here, these are applications with nationality grouped by world region, 2 regions responsible for the vast majority of asylum applications, something that is reflected as well in grants at initial decision. So Africa and the Middle East, due to conflicts, war, some of which Britain has intervened in. So that gives the general pattern. Other continents, very few people apply and are granted asylum. Here are the top 10 nationalities of asylum seekers to the UK. In 2018, Iran and Iraq conflict, and with Iran also political dissidents make up a large number of the applicants. But what's really interesting here is the substantial difference in the share that are ultimately granted protection, so that while Eritrean nationals have a very high chance of being granted asylum, 88%, taking into account appeals, Indian nationals given relatively short shrift. So that's the picture in the UK. Now it's sufficient to take a step back and we can view the UK in international perspective just to see how great is the number of people that apply for asylum in the UK. This is adjusted according to the population. So this is the estimated number of asylum seekers per 1,000 of the population. So Cyprus and Malta are quite small countries, explains in part why that's so high. Although Germany in 6th place, big population, but also a large number of asylum applicants. And we can see here the United Kingdom in 21st place, about 0.6, and about half of the average for the EU, 28. So that is the contents of my briefing. And the question now is, well, if you had to decide to focus on just 1 or 2 of these findings that would maximize the appeal and interest of the briefing, which 1 or 2 would it be? And some of the considerations that I bore in mind were, well, it has to be of contemporary interest. So that more or less rules 1, 2, and 3 out, which has more of an historical orientation. Of course, if it were the case that suddenly we had record numbers in 2018, that might make them newsworthy, but not otherwise. So I focused instead on the waiting times. It's novel, it's not widely known, it's on a fairly exotic topic, but another major consideration is that it speaks to inequality, injustice, or failure, and especially where this is failure on the part of the government, news people like that. And so this is something that I focused on. And we can see here the way that we phrased our press release. More asylum seekers are facing long waits for decisions, very simple, declarative speech. And that ultimately got picked up by a number of news organizations. They can use more evocative language like limbo, but I think really getting a very clear message and presenting that information as clearly as possible, hopefully summarizing it in a single chart, that really maximizes the chance of it getting picked up. Okay, so that's all I wanted to say for today. Thank you very much for your attention, and I will turn over to Charlotte, who's going to focus in on a particular aspect of asylum seeking.
Thank you, Peter, for that excellent introduction into asylum law and policy by way of an overview. And I hope that that will provide a helpful outline of the presentation moving forward when thinking about FGM specifically. I'm just going to, there we go. Now, in terms of an outline of this presentation, we're going to look at the statistics relating to FGM and asylum claims, and then move on to FGM protection orders. I'm going to take you through a number of reported cases specifically about protection orders and look at the overlap and indeed the gap between asylum claims and FGM protection orders. So what are the statistics when it comes to FGM? Well, FGM is primarily a practice that is performed internationally in a number of different countries. We understand that at least 200 million girls and women have been cut in at least 31 countries, if not more. The practice is understood to be universal in countries such as Somali, Guinea, and Djibouti, around 90%, and even in countries such as Egypt, a case of which I'll come on to shortly. In England and Wales, it is believed that 103,000 women and girls are living with FGM, according to a study which was undertaken by City University, and around 60,000 girls are understood to be at risk of the practice. Between April and September 2019, there are a total of 45,000 cases of attendees to health services that occurred in England. I should say that's April 2015 to 2019, by individuals who have been identified as suffering with FGM. It's understood that they're not duplicates, so it's not the case that two patients have been double counted. So that gives you an idea not only in terms of the international dimension of the practice, but also in terms of the practice being carried out in this jurisdiction in England and Wales and throughout the UK. Now, as Peter touched on earlier, the statistics relating to FGM and also asylum claims are unfortunately not necessarily straightforward. And as Peter said, it's not always clear what recording facilities the Home Office have available to them. And even when they do, it's not always transparent. According to the Home Office, they don't record statistics on the numbers of asylum claims where one of the claims is relating to FGM. So it's not known how many cases take place each year in this jurisdiction, or indeed in the EU more broadly. What we do know, though, is that of the 25,000 girls and women seeking asylum in Europe in 2014 alone, 71% have been subject to FGM, but that's no indication necessarily of how many were claiming asylum on the basis of FGM or their children being at risk of such. In 2011, 2,410 women claiming asylum in the UK were from FGM risk countries, so the countries that I spoke about in the slide before. which equates to about 27.4% of female asylum claims. And we understand that the number continues to increase each year. So what the suggestion is there, that at least around a quarter of those are relating to FGM cases, or certainly FGM countries where there is a risk. Now, what does the law say when it comes to asylum claims and FGM? Well, the 1951 Refugee Convention makes very clear that any refugee can seek asylum, can seek refugee status on the basis of a well-founded fear of persecution. And the grounds for that are fairly wide-reaching, and they do include membership of a particular social group. And as was established in the leading case of Fauna, which is in 2006, a House of Lords case, this does include FGM. So FGM does constitute persecution within the Refugee Convention and the meaning of that. And so there ought to be no difficulties in a woman or girl claiming asylum on the basis of persecution due to risk of FGM, or indeed if someone has been cut and may be at risk of being cut again. Now, as Peter mentioned, when it comes to asylum claim refusals, you can often have a refusal letter that exceeds 10,000 words, and it can be very dense, difficult to understand. And as a lawyer going through these types of refusal letters on a regular basis, what I tend to see is a pattern. So I tend to see what almost appears like a copy and paste exercise, with parts of one refusal letter relating to one FGM case being pasted into another refusal letter in another case. And so these are the types of common arguments that I see when asylum claims are refused in FGM cases. So one is that in the majority of asylum cases, in fact, not necessarily just relating to FGM, there does appear to be a very high standard of proof that's attached. So it's supposed to be the civil standard of proof, which is on the balance of probabilities, and it's supposed to be even less than that when it comes to asylum claims, so reducing the burden of proof even lower. But in fact, what the Home Office often seek is supporting evidence, but one has to question, how can they possibly prove that their child will be cut on return? Now, we know that a mother having been cut is one of the single biggest indicators that their child will be cut, but the Home Office don't necessarily accept that that is the case and take a very subjective view. And I say subjective being on the basis of how the Home Office would act, or how a reasonable person, perhaps a white privileged male, often would respond to such a situation of FGM, rather than looking at the particular context of the individual who may be subject to FGM, for example, in Sudan or in Somalia, who may already be vulnerable and socioeconomically deprived. Second to that is credibility. This is one of the core issues in asylum claim refusal. So, for instance, a delay in claiming asylum can unfortunately still be fatal. So if someone comes to the country perhaps on a student visa and doesn't claim asylum until that visa has expired on the basis of FGM, even though they're always at risk of the practice on returning, or their child might be, that delay can sometimes be fatal. Sometimes a lack of knowledge about the FGM community and prevalence rates of your client can be very difficult for the Home Office to understand, not recognising, for example, the low literacy rates and education rates in their particular home country, and therefore understanding why they may lack that knowledge. Not reporting FGM to the police in their home country. Well, we often know that it's unlikely that state-based resources such as the police will act in countries where FGM is prevalent. For example, in Somalia, it's unlikely the police will necessarily respond to such cases in a way that you'd expect UK authorities to respond. And yet, again, there isn't always that acknowledgement by the Home Office. The third common argument that we see is internal relocation. Apparently, it's often easy for claimants to internally relocate within their home country, even if that individual may be a single mother whose child may be at risk of FGM, and she may be a lone parent, as I say. And often the argument can be, well, there are a number of NGO resources available in this particular country, and sometimes these NGOs are actually funded by the UK government through DFID and others. And so they are often considered to be well established and set up and have resources. And so they're considered to be a support base where women and girls can seek refuge. And finally, perhaps somewhat surprisingly, I see this occur in a number of cases, it's argued that there's sufficient state protection to prevent a girl or woman from being cut on the basis that FGM is a criminal offence, such as in Nigeria and other countries, even if the law is very rarely enforced. So that's an overview of FGM in the context of asylum claims. I now want to move on to speaking about a different legal remedy which has overlaps with asylum law. So in 2015, the UK government introduced FGM protection orders, which were modelled on forced marriage protection orders. Now, these orders were introduced after a lot of lobbying by a group of human rights barristers and lawyers such as myself and many others, including Dexter Diaz QC, Felicity Gary QC and others. Now, the purpose of FGM protection orders is that they are an injunctive remedy where you can apply for these orders ordinarily in a family court to stop FGM from taking place, whether in this jurisdiction, in England and Wales, and indeed FGM protection orders have now been rolled out in Scotland, or in other countries. And so you can see from the Act at subsection 4A, the terms of an FGM protection order can relate to conduct outside of England and Wales. So it's not necessarily just in this country. And where the courts will consider all the circumstances, including the health, safety and well-being of a girl, to be protected when deciding whether to make these orders. And in fact, often it's a very low threshold, and that should be the threshold that's applied for an order to be granted. So as I say, FGM protection orders, they're a novel legal remedy. They were introduced in 2015, and the idea is a preventative measure. The types of injunctive remedy that can be applied, for example, is to prevent a girl from being removed from this jurisdiction and going to another country where there may be high prevalence of FGM. And in addition, they can be a breach of an order, can result in 5 years of imprisonment. So it can have quite serious consequences if the order is breached. In addition, for instance, the court may order medical examinations, and there may be risk assessments ordered in respect of whether FGM is likely to be performed abroad. The order may relate, as I say, to conduct in this jurisdiction as well as others. So looking at the FGM protection order statistics, just going to move this person, they can always come back. FGM protection order statistics. So looking across the spectrum from when FGM protection orders were introduced in 2015 to September 2019, we've seen a total of 408 applications, of which 489 orders were made. So the orders can relate to multiple children in the household, which is why you see an increase in the numbers of orders made, or indeed the court may make the orders of their own motion. So they've been really rather successful in a short time frame in terms of the number of preventive orders that have been granted by the court. Now, this is one of the first cases that came before the High Court, which then became a precedent-setting case and went to the Court of Appeal and back to the High Court. And I represented the mother in this case of X. Now, in this case, the mother had a child, a British child in this jurisdiction, and her father is Egyptian, and he lived in Egypt. And the father couldn't get a visa to come to this jurisdiction, and so he was effectively stuck in Egypt. The mother wanted to take the child to Egypt to visit the father, but there were concerns that the child would be subject to FGM by the paternal family because many members of the paternal family had been cut, and there's high prevalence of FGM in that country. Now, in the end, the court was very concerned about the risk of FGM to this child, a British national, and so the court initially ordered a full ban, a full travel ban, to prevent the girl from leaving the jurisdiction until the age of 16. And at that point, she could return to court to vary the order. Now, that was considered by the courts to be disproportionate. And in fact, it was instead considered that there ought to be other considerations of how the child can visit her father in Egypt whilst doing so safely. And so the court relooked at the case with expert evidence and decided that the child could visit Egypt, considering the macro factors of prevalence of FGM in Egypt and the micro factors of the paternal family and the risk of them performing FGM. And they allowed this little girl to visit her father for just over a week. And that went very smoothly, as I understand, and the case returns back to court to consider whether she can visit again. But it shows that even where there is a medium risk of FGM, in fact, some experts said there was a low risk of FGM, the court was very quick to act and to prohibit this child from visiting Egypt, to impose a blanket travel ban initially. And yet, I want to contrast that case of Re-X with the second case of Re-A. So Re-A, this is again another precedent-setting case. This went before the president of the family division, has just recently gone before the Court of Appeal, and I represented the mother in this case. And this was a case where there is an overlap with asylum law. So in this case, the mother had applied for asylum on the basis that her daughter would be cut if she was returned to either Sudan, which was their country of origin, or Bahrain, as they had Bahrainian citizenship. The Home Office didn't accept that was correct, neither did the courts, and they refused her immigration application, and she was effectively appeal rights exhausted. The family were then served with removal directions, and they were told they'd be boarding a flight in less than a few days. As a result, the National FGM Centre and also the local authority, Children's Services, were very concerned about the risk of FGM. And so they applied for an FGM protection order, which is this injunctive remedy that can be applied for through the family courts. And that was due to the concern this girl would be cut if she was deported. Now, of course, that contrasts with what the Home Office said and the Immigration Tribunal said. They considered that there wasn't a risk. So you have to consider the balance of the family courts thinking there is a risk and the Home Office saying that there's not. Now, the family court granted an injunction against the Home Secretary and prohibited the removal of the girl from this jurisdiction. The case went before the president of the family division, and the president confirmed that he didn't, nor did any of the family courts, have the power to restrain the Home Secretary from exercising their immigration powers. Only the immigration courts have such power. And so the FGM protection order, in many respects, was rather weak in that it couldn't prevent this little girl from being removed from the jurisdiction because it couldn't infringe the powers of the immigration jurisdiction. However, what it did do is it went on, and it went on before Mr. Justice Newton, and there was a further decision in 2020, which is set out in the slides. And in that decision, Mr. Justice Newton heard from a number of expert evidence. He heard from psychiatrists, the National FGM Centre, the social worker, the Children's Guardian, country experts in Bahrain and also in Sudan. And Mr. Justice Newton decided, having heard all of the expert evidence, that he considered that the mother was a credible witness, which contrasted massively with what the Immigration Tribunal had found. And he also found that the mother was very vulnerable, suffering with PTSD. Again, the immigration courts didn't consider that. And he found that there was a very high risk that this girl would be cut almost definitely if she was returned to Bahrain or Sudan. Now, as a result of that family court ruling, that cannot bind the Home Office, so that cannot prevent the Home Office from deporting her, even though there's a high risk of FGM, but it can put pressure on the Home Office to reconsider the decision. And that's thanks to FGM protection orders in allowing that fact-find exercise to take place. There is now Home Office guidance concerning FGM protection orders. And as you can see, it's not particularly clear in terms of the weight that will be attached to forced marriage protection orders or FGM protection orders. Instead, it's seen as they'll be considered in the round and given appropriate weight in particular cases. And I see instances of FGM protection orders having been granted, and yet there's a decision not to give that appropriate weight by the Home Office. Now, looking at Re-X and Re-A, you can see where the case concerns a British national who has immigration status, the courts are very proactive in preventing that girl from being removed from the jurisdiction. They will impose a full travel ban. But when it comes to a girl that doesn't have immigration status, the courts are unable to act because they don't have the power, and they're not able to necessarily protect girls who are at risk of FGM when they have insecure immigration status. And as a result, I've suggested here a number of gaps and lacunas under FGM protection orders, and also within asylum law, as Peter mentioned, in not necessarily taking into account the significance of FGM upon the lives of girls and women, but also the importance of providing protection not only for British nationals, but also providing protection for those who are not. After all, it's imperative that the state takes proactive measures to prevent FGM from taking place. I'm going to leave it there, and these slides will be available through either the Department of Sociology at Cambridge, or they will be available through my chamber's website at Goldsmith Chambers. We have a little time now for questions. And so what I would suggest that people do is write in the chat box if they do have questions, and we will try to take those questions as best as we can. And then perhaps you can unmute yourself and put on your video, give your name, and also ask a question. We'll try to answer that. There was a question initially from Vicky David. I hope I pronounced your name correctly. And I think you're asking as to whether Peter's presentation was about the UK or was about England and Wales or Scotland. Perhaps Peter could assist with that.
Yes, it was about the UK.
I'm grateful. Thank you for clarifying. In respect of my presentation, it was specifically about largely England and Wales, but as I say, FGM protection orders have now been rolled out to Scotland. There is a question from Musa Mehman. Are you there, Musa?
Yes, Charlotte, I am here. Basically, I'm involved in the presentation, preparation of materials in addition to safeguarding victims. And I just find that sometimes we may not be as aware or knowledgeable in the area around FGM. And whilst I usually encourage my recruits to be professionally curious when attending complainant's home address and not being task-driven, and we have the powers in relation to, we know what we can do, make the arrest and safeguard them, and under section 46 if needs be for children. But I was looking at, in relation to being proactive as opposed to reactive, any signs that they ought to be looking out for than some of what we may already be aware of. Like I think you mentioned something to the effect of, if a mother has already been a victim of cutting herself, the likelihood of a child suffering the same is quite high. Are there any other signs to be mindful of when attending addresses?
Yes, thank you. That's an excellent question. There are resources available on the National FGM website, and they set out some of the signs that you need to consider, because there are a range of social workers that work at this organisation, so they have hands-on advice. But yes, I mean, of course, considering that a mother herself has been cut, perhaps other family members may have been cut, there may be a summer holiday that's arranged in a high prevalence country. I would suggest considering that and whether that may give rise to additional concerns. And, you know, in addition, I would suggest that you have very frank conversations with the family and gain their trust so that you can talk about these issues. I think that's probably one of the most important things, so they don't feel stigmatized or labeled or targeted. Does that help?
You're very helpful. Thank you very much for that, Charlotte.
Thank you very much. We had a hand up from, was it Ben Howard?
Val Howard.
Val Howard, sorry, forgive me.
Thank you. Thank you, Charlotte, for your presentation. Really good. I think it was just a question, and I'm sure, I don't know, I'll ask it anyway. So I was projects officer in the police for honour-based violence, forced marriage and FGM, and have since left and delivered training to professionals independently. One of the cases we had was mum was white British, dad was a foreign national, and mum had fled because of domestic abuse. She was totally so afraid that her girl was going to be abducted by dad and taken overseas for FGM. A, she wouldn't be able to get access to the child because the child was overseas, and B, for FGM as well. And at the time when we had the strategy meeting, discussions were around prohibited steps orders.
Yes.
So what would have been the more powerful tool, or would you have done both?
You can certainly do both, but if you consider that there's a risk of FGM, I would have perhaps in that situation have applied for an FGM protection order in your local family court that's designated to deal with FGM, and you can find on the Ministry of Justice website the courts that deal specifically with FGM, because effectively an FGM order is an injunctive order, so you can get the same terms of prohibited steps order within the FGM order, but it does also include other remedies, for example, medical examinations if that's required, or the holding of passports, or even Part 25 applications if you're thinking about expert evidence. It just hones in on the fact that the core issue is FGM, so you have a specialised judge who should know how to respond to those cases.
Yeah, no, and it's what we did. It was an FGM protection order. Thank you.
Good, I'm pleased to hear it. We have a hand up from David Lehman. David? David Lehman, are you there? You need to unmute yourself. I can unmute you.
Yeah, I am here. Can you hear me now?
I can hear you perfectly, thank
Hello,
you.
yes, well, I'm not an expert or professional in this field, but the two expositions were brilliant, really. And I want to ask Peter about, just to give us a little more, I mean, it's often, I think, when one reads about these stories in the papers, one wonders what the culture is like in the Home Office. And he gave us some indication of that. The people who are taking the decisions, he said there were 200 people, I think?
Yes, working simultaneously.
With a total of, I don't know, 100,000. I don't know how it links up, but they have to get through so many, and they're under a lot of pressure, aren't they?
Yeah, so in recent years, they've had to get through 40,000, process 40,000 asylum seekers. So that's probably about 30,000 applications, and then some of those applications are for the main applicant and any dependents they might have, like children.
Yeah. Well, it's very complicated. I mean, and what sort of level of education do these people have?
Yeah, they have a university education. I don't think there's anything specified, and they're paid in the low 20,000s when they...
Below 20,000?
Low 20,000s.
Low 20,000. Still, it's not very much, is it? And they work in Croydon, or they work all over?
Yeah, they were especially there, but there's a few offices around the country, but...
Yeah. And what do we have any, I suppose it's not possible, is it, to do a sort of research on the atmosphere, the pressures they are under, especially, are they given incentives? Are there implicit or explicit incentives for them to reject asylum applications or indeed immigration applications? Do you know anything about, or does anyone know anything about how the system works?
Yes, some whistleblowers have said that explicitly it's not just about processing applications, but giving negative decisions. So there is a little bit of work on that. There is some outdated research that looked at actually what the culture of life is like within these bureaucracies. And some of that more recent work is quite interesting, because previously it had been assumed, it's easy to assume, oh, well, you're dealing with cold, heartless administrators. Actually, some recent research has come out to say, well, this culture of disbelief that operates on the part of the caseworkers operates for their own psychological health, because they're hearing the most horrific stories from asylum seekers. And it's actually not healthy for the caseworkers. It's easier for them to entertain that what they're being told is not true and hasn't happened. And that's because so much of the abuse that they hear would take a toll, and it does take a deleterious toll on their mental health, the mental health of the caseworker. So that's some of the recent research that's come out. In general, there's not all that much known about it, though. In recent years,
well, I'm not surprised. I mean, it wouldn't be allowed. Finally, can I have one more? It's about, it was interesting that Charlotte mentioned the use of a lot of experts in the FGM apparatus. My suspicion, but it's just a suspicion, is that when it comes to immigration and asylum seekers, the Home Office does not like to hear the views of experts, and especially sort of anthropologists and people like this who have inside knowledge of these societies, and they tend to rely on diplomats who are, who obviously don't have that sort of expertise. Do you have? Is my suspicion correct?
Yes, I think that is broadly correct, yes. In immigration cases, it can be rare sometimes to even have experts. In other cases, there will be perhaps one expert, maybe an anthropologist if you're lucky, and that can be due to legal aid cuts. And so if the mother, and it usually is the mother who applies for asylum, has legal aid, you may be able to get one, sometimes two reports, but only at a very low rate. But often they're privately funded and simply can't afford thousands of pounds on expert reports. Whereas under FGM protection orders in the family court, there is legal aid available for these expert assessments. And so that's why you can find yourself, if you have a case that the judge thinks is credible, with some an anthropological report. So we had a Professor Tamsin Bradley from Portsmouth University who acted in the case of REA and REX, and then a Bahrainian country expert, sometimes Sudanese expert, psychiatric expert report, sometimes a medical report to confirm FGM. So you can end up with a whole host of expert reports in family courts due to the fact, I think, that the priority and the paramount consideration is the child, and that's not always the case in immigration courts. You tend to find that the priority is more public policy on preventing immigration and having a hostile environment.
Yeah, thank you.
Thank you. We have time for a couple more questions. There's a question from Sarah Shani. Are you there, Sarah?
Hi, Charlotte, I'm here.
Hi.
It was just in relation to, for example, like the case of REX for the parents in Egypt. Does that have any sort of impact on parental alienation in terms of if the order says father's not allowed to come to the UK, but also child's not allowed to go to Egypt? But also in terms of cases where, for example, a majority of cases come through sort of social services where it's been picked up from, or children have been speaking to their teachers. If that's not the case, how do you get a case? Is it in terms of, some families might appear to be normal, but how are their cases being picked up?
I haven't seen a big crossover between FGM and parental alienation. I've only seen that arise in one case where there was already a lot of hostility between the parents, which then resulted in, I think we can hear some background noise. I'm just going to mute, there we go. Yes, so only in one case have I seen that arise where there was a lot of hostility and tension between the parents already, and that led to the mother making an application for an FGM protection order and the father saying she was doing this out of spite and to alienate him. So I've seen overlaps there, but it's very rare that does happen. And in the majority of cases, they tend to be led by the mother, but sometimes with the support of the father. And in the case of REX, both the parents were still very much together. And so they wanted to be together and they wanted a relationship. We have also a question from YN. YN, are you there? No? Okay, there's a question here. Is the fact a child already got cut in their home country can be a reason for providing refugee status or prohibiting from leaving the UK? Not necessarily, no. That would be very difficult if the child has already been cut and it's agreed that it's in that particular community, the child would only be cut once, unless perhaps she has a sibling. It may be difficult to claim asylum on that basis unless there are other grounds related to perhaps forced marriage or other forms of gender-based violence. There was also a question from Anne-Marie Middleberg. Is Dr. Anne-Marie Middleberg here?
Yes, I'm here. I didn't ask a question, it was just a remark on Peter Walsh's presentation, because what you explained related to the 6-month time and all the delays, we see that in the Netherlands as well. And it is really a huge problem. So I fully agree with you 100% that we need to put more emphasis on this and that this is really problematic. In addition, I also would like to react, if possible, on the comment of one of the previous speakers related to expert statements, because I myself serve as an expert witness, sorry, in FGM asylum cases. So very often I write expert reports for women who applied for asylum, or for their daughters. And it's very good to see that at least judges in the Netherlands take those expert statements very seriously. So we clearly see that that makes a difference, and I'm very happy to be able to make the difference for those girls and women that, you know, face really, like in so many cases. We have many cases in the Netherlands focusing on women and girls from Guinea. And as we know, the prevalence of FGM in Guinea is really, really high. So those girls and women, they really face a real risk of undergoing FGM when they are sent back to their home countries. So especially in those cases, I write expert statements explaining the situation, the real risk that those girls and women face when they are sent back to their countries of origin. And then you clearly see that, you know, the judges lack those expertise, and also the Dutch authorities. And it's good to be able to make a difference for those girls and women.
Thank you, Dr. Middleberg. We have a question also from Tobe, which relates to what Dr. Middleberg was speaking about a moment ago. She asks, have you knowledge of comparative studies on asylum grounds of FGM in other places, such as Germany, France, and the USA? Tobe Leven, are you present on the call? No, she may have left now. I don't have any comparative studies that are available to me that I can point you to directly. I will certainly use my best endeavours to have a look. From the studies that I have seen, and in fact, Dr. Middleberg wrote a paper about asylum claims of FGM in some of those countries.
Hi, Charlotte, I'm sorry, I'm here.
Oh, excellent. Thank you, Tobe.
I was clicking on the wrong microphone.
Excellent. I was just, I understand your question is about comparative studies relating to asylum.
Right.
On the grounds of FGM. Do you have experience in dealing with asylum claims in other countries?
I have one in which I needed to defend a woman from the Gonja ethnic group in Ghana, which required at least 50 hours of research. And in that respect, I could identify with the amount of work that's required in all of this. I did want to say that of importance to the judge was the specificity of the unique experience within the ethnic group. And there are such a myriad of minute details that enter into the factual and believable account.
Yes, absolutely. Perhaps Dr. Walsh could come in here and comment on the amount of work that is required in making sure that caseworkers have all of that knowledge available to them. There's another question here from Jaria, who says that there are over 50 countries where FGM is practiced, some in specific countries. It concerns me that there is not wider knowledge with decision makers in communities.
So just to speak to that point about asylum caseworkers, the patterns that do emerge from somewhat scant evidence, usually through whistleblowing, is that the pressures are very great, that the documents, as you touched upon, Charlotte, are long and complex, and that the job isn't very enjoyable. They don't enjoy being there, and that's why they leave in such large numbers. They constantly feel the hand of their superiors saying, okay, these have to be processed in this time. 5 a week, might be as many as 50,000 words. Pressure perhaps also towards rejecting rather than accepting, and rejection decision letters typically quite a bit longer, thousands of words longer than our accepting ones, which increases their workload still further.
Well, thank you very much, and thank you, Dr. Walsh. for your excellent presentation and your very thorough overview of asylum law and policy in this jurisdiction. And thank you everyone for attending today and listening so closely and carefully, and for your considered questions. We're going to end the webinar now, so you can go, and if you're in London or the vicinity, you can enjoy this glorious sunny day that we have. The recording, as I say, will be available either on the Department of Sociology website at Cambridge or Goldsmith Chambers website, which is where I'm a barrister and where I practice. And just a short apology to those who joined us first thing and heard me shouting at my little puppy. I've just had a little puppy, and he was making quite a lot of noise. He wanted attention when the webinar started, so apologies for not having muted myself. And thank you again for attending. I'm going to end the meeting now. Goodbye.
Thank you. Thanks to everyone for being here, and thank you, Charlotte, for organising.